We're here for a pretrial and a bond violation. We're ready to resolve the bond violation. She will admit to the allegations of contact and would like to provide the court some context if you would allow that.
Go ahead.
Your Honor, I do admit I was wrong. Let me start there. I was wrong. When I got out, I thought that she was going to be at her mother's house. When we went to arraignment, they said she's going to be at her mother's house and I could return to my home. But I didn't know until the end when they were releasing me that I could not return to my home. So that was a surprise. And I called the police like I was told to do. She packed up some of my stuff. She left our marriage license on the front of my driver's side. I didn't know we were married, Your Honor, because we had gotten married a couple of weeks before and we had talked about not filing the marriage license. And so she filed the marriage license after the incident. And I did not know that we were married until she left it on the seat. And so when I did call, she had packed it up. She'd packed up my stuff. I did leave, but then I realized she didn't give me shoes. And so I called the police officers back. I was away from the house. I was down the street. I was trying to do the right thing. They got called emergency, so I was waiting longer. And I saw my son get out of the car. And I saw her pull the trash cans up. I did not approach them. I did not try to approach them. But when I saw my son, that's what broke me, is I saw my son. And so I did violate, Your Honor, I did violate, but I was not aggressive. I did not approach them. I did not come near them. I did send text messages, but I didn't understand with the marriage license and it broke me. My son broke me. That's why. And I wanted to know if there was hope. That's all. And I do acknowledge I was wrong. I do learn, and I will not contact her again. 100%.
I will add, Your Honor, she has been in custody for about 5 days, I believe. If she were to be released, she would be staying at a hotel nearby. The house was recently flooded, so she actually has funds from the VA to stay somewhere else. There's work being done on the house. So given her admission and her owning up the fact that she did violate the court's orders, I'd ask that you sentence her to those 5 days.
What are we doing on the pretrial?
We're asking for an adjournment on the pretrial.
Do people have something to say in this?
Yes, Your Honor, we would object to that. Given the nature of these texts and the fact that they were sent, she was, I believe, arraigned on the 22nd, sent these immediately after getting out and being told not to have contact. And in those messages, directly acknowledges that she was not to be having contact, continuously telling the victim not to contact police, and then sending other manipulative messages to the victim, intending to make her feel bad for contacting the police or trying to contact police.
When's my next day?
May 13th.
May 13th.
Yes.
I'll adjourn the pretrial in this matter to May 13th. At that time, I'll also sentence her on the bond violations on that May 13th, and then her bond at this time, given what I've seen here, her bond will continue as revoked.
Yes, Your Honor.
Thank you.
Teresa Clare on behalf of probation. Your Honor, Mr. Anderson is before the court for a violation of probation hearing. Mr. Anderson violated his GPS tether that he had on. He entered into the exclusion zone, including going to the victim's residence, and also took her vehicle. They then tracked the GPS where he removed the tether and left it in Flint. Mr. Anderson failed to enroll in the domestic violence program, and he failed to continue to report as he should. I would also like it known to the court when Mr. Anderson walked in and up to the podium, he was looking, trying to make direct eye contact with the victim who is present today. Your Honor, given the violations of Mr. Anderson and his clear non-compliance with what this court ordered, probation is asking that the court sentence him to 93 days in jail, credit for 33 days that he served to date, to serve the balance, waive remaining terms of his probation, accept his financial obligations, and discharge him from probation without improvement.
Ms. Coons.
Your Honor, my client would like to admit to the violations with explanation. I think that he is very apologetic about his actions. He just lost his sister and he's grieving right now. He's not in the right state of mind, and he understands that he has made some poor decisions here. As to the no contact violation, he had news that the complaining witness was possibly selling his stuff. He does understand that the proper remedy would have been to go through civil court after discussion with him. And particularly to the vehicle was in both their names, but again, I did discuss the civil court with him. As to the lack of payment, it's due to a lack of monetary funds. His sole source of income is from Social Security. He's been homeless since the beginning of this case and just fell on a hard patch in life. And that goes for the domestic violence program as well as to why he didn't complete that. In addition, he did not have transportation. So, Your Honor, we would leave it inside the discretion of this court as to the recommendation, but we would ask for some type of leeway on account of him just not being in the right mind state. He's grieving and he just lost his sister.
And Your Honor, I just would also like to make it known to the court. I had a meeting with Mr. Anderson. It was made extremely clear where he could and could not go. So it wasn't a discussion made about the truck, as he indicated that it was in both of their names. He was told what he needed to provide to this court if that he wanted to pursue that. Just taking it upon himself and leaving his daughter's home where he was staying in Detroit and coming here and going to her home and taking a vehicle was against what he was instructed to do. He knew full well that he should not have been in the exclusion zone, period.
Anything you want to say, sir?
I came down here when I seen her, and I have friends here that I've been, and I understand that when I talked to you, you made it clear to me 5 miles. I understand that. But she told me that the police don't have time to be running over there to see about my things, and that I shouldn't come.
She who?
The lady that was just talking.
Ms. Polera?
Yeah. And that you said not to even come to Washtenaw County at all. And I'm like, you know, she wrote it on this paper. So, Your Honor, I'm just
Well, why'd you take the GPS tether off then?
I was going through some things. I lost everything. I was wrong.
Oh, I know.
And I understand. I mean, I was going through some things, Your Honor, with this whole situation.
Court will accept the admission to the violation. Court will follow the recommendation of probation. I will waive remaining terms accepted as financial obligations, discharge him from probation without improvement. Sentence you to 93 days, Washington County Jail. Credit 33 served. Defendant is to serve the balance. I'm not even going to consider an early release. Thank you.
Thank you, Your Honor.
All right, sir.
Ali Rasa. Main Tumhari Puri transcript KO carefully analyze Kark Usko cinematic courtroom documentary narration style main convert. Kia Hai, Bilkulas detailed courtroom storytelling style main Jo Tum Apni YouTube audience, US viewers. Kela use card ho? Yeah, approx 5-minute voiceover summary high, 5-minute courtroom summary a dramatic courtroom hearing. Unfolds as a judge confronts two separate defendants accused of violating strict court orders. What begins as a routine pretrial proceeding quickly turns into an emotional and serious discussion about accountability, court authority, and the consequences of ignoring judicial orders. The first case involves a defendant appearing before the court for both a pretrial hearing and a bond violation. Her attorney informs the judge that the defendant is prepared to admit to the allegations that she contacted the protected individual despite being explicitly ordered not to have any communication when given the opportunity to speak. The defendant addresses the court directly and immediately acknowledges that she made a mistake. She admits that contacting the person was wrong, but asks the judge to consider the circumstances that led to the violation, according to her explanation. The situation began shortly after she was released from custody. She says that during the earlier court proceedings she believed the other individual would be staying at her mother's house, which made her think she could return to her own home without violating the court's order. However, she later learned that she was not allowed to return to the residence at all, something she claims came as a surprise after she was released. She explains that when she arrived at the house, she contacted police as she had been instructed to do. The other individual had already packed some of her belongings and left them behind. But the situation took an unexpected emotional turn when she discovered something shocking inside the car. The defendant tells the court that the other person had left their marriage license on the driver's seat. According to her, she had believed the marriage paperwork had never been filed, and she had no idea that they were legally married until she saw the document. Overcome with emotion and confusion, she says the situation became even more difficult when she saw her son nearby. That moment, she tells the judge, broke her emotionally and led to the messages she sent afterward. She admits that she did send text messages, but insists she never approached the other person physically or acted aggressively. Still, she does not try to deny responsibility. She tells the judge directly that she violated the court order and promises that it will never happen again. Her attorney also asks the court to consider the time she has already spent in custody, approximately 5 days, and explains that if released she has alternative housing arrangements. Because the home involved in the case recently suffered flooding damage, the defendant reportedly has funds from the VA that would allow her to stay in a hotel while the situation is resolved. Despite the explanation, the prosecution strongly objects. The prosecutor argues that the messages sent by the defendant were not innocent mistakes. According to the state, the texts clearly show that the defendant knew she was not supposed to contact the victim. In fact, the messages allegedly include statements acknowledging the no-contact order while simultaneously attempting to persuade the victim not to call police. The prosecutor describes the messages as manipulative and intentionally designed to pressure the victim emotionally. After reviewing the situation, the judge makes a decision. The court schedules the case to continue at a later pretrial date and states that sentencing for the bond violation will occur at that time. However, given the evidence presented, the judge orders that the defendant's bond will remain revoked, meaning she will stay in custody until the next hearing, but the courtroom drama doesn't end there. Immediately afterward, the judge hears another serious violation case involving a different defendant, Mr. Anderson, who is accused of violating multiple conditions of his probation. According to probation officials, Anderson violated the GPS tether monitoring his movements by entering a restricted exclusion zone, specifically the area surrounding the victim's residence. Investigators also claim that he went directly to the victim's home and took her vehicle. Authorities were able to track the GPS signal and eventually discovered that Anderson had removed the tether device and abandoned it in another city. The violations didn't stop there. Probation officials also informed the court that Anderson failed to enroll in a required domestic violence intervention program and stopped reporting to supervision as ordered. Perhaps most concerning, the probation officer tells the judge that when Anderson entered the courtroom that day, he appeared to be attempting to make direct eye contact with the victim who was present in the gallery. Given the seriousness of these violations, probation officials recommend that Anderson be sentenced to 93 days in jail, with credit for the 33 days he has already served. When Anderson's attorney responds, he acknowledges the violations but asks the court to show some compassion. The lawyer explains that Anderson recently lost his sister and has been struggling emotionally. According to the defense, the grief combined with homelessness and financial hardship caused him to make several poor decisions. The attorney also claims that the vehicle Anderson took was actually registered in both names, though he admits that the proper legal approach would have been to resolve the dispute through civil court rather than taking matters into his own hands. When the judge asks Anderson to speak, he admits that he made mistakes and acknowledges that he understood the restrictions placed upon him. However, he says he was overwhelmed by the situation and simply made bad choices after listening to both sides. The judge delivers the final decision. The court accepts Anderson's admission to the violations and chooses to follow the probation department's recommendation. Anderson is sentenced to 93 days in jail, with credit for the time he has already served. The judge also orders that the remaining terms of probation will be waived, except for any outstanding financial obligations. In closing, the judge makes it clear that early release will not even be considered. With that ruling, the courtroom session ends, serving as a powerful reminder that when courts issue protective orders, probation restrictions, or bond conditions, violating those orders can lead to immediate and serious consequences.